Mediation and arbitration. You'd be forgiven for thinking these processes are one and the same, as they're often viewed with confusion. While both aim to achieve the same end, conflict resolution, important differences exist. So how do you distinguish the two? Mediation is when disputing parties hire a neutral third person to help them explore possible outcomes in hopes of reaching a settlement and avoiding any further legal proceedings and costs. In mediation, the parties are in control of the outcome and any settlement is only by mutual agreement. The mediator facilitates the settlement and may provide the parties with an opinion about possible outcomes in litigation, but the mediator does not make a final decision. If mediation doesn't result in a settlement, the parties are free to pursue litigation or arbitration. Arbitration is a process in which parties to a dispute hire a neutral third person to hold a hearing, listen to evidence and arguments, and then decide who is right and who is wrong and how much will be awarded to the prevailing party. When parties agree to arbitrate, they give up their right to trial by judge or jury, and they give up their right to appeal a decision they do not agree with. The arbitrator's decision is almost always final. A mediator is a neutral facilitator who uses the power of persuasion to try to steer the dispute to a mutually agreed upon solution. An arbitrator is like a judge who listens to evidence and makes a final binding decision. Paragraph 30 of the purchase agreement obligates buyers and sellers to try and resolve their differences in mediation before pursuing any other legal action, such as a lawsuit or arbitration. Bear in mind, this isn't optional. It's contractually obligated. It applies even if the parties do not initial the arbitration clause. Paragraph 31 of the purchase agreement provides the option for buyers and sellers to agree that instead of going to court, they will arbitrate disputes that are not resolved in mediation. Be aware that this paragraph is only binding if each party initials the clause or if they incorporate it into a counteroffer. Of course, the parties can always mutually agree to arbitration at any time. So why would a buyer or seller agree to arbitration if they are giving up some legal rights, you may ask? The decision to arbitrate rather than litigate involves trade-offs. Arbitration hearings are private, not open to the public. Arbitration decisions are confidential and not subject to public review. Buyers and sellers can choose their own arbitrator and select, if they desire, a person with subject matter expertise. An arbitration hearing may often take place sooner than a court hearing and therefore offers possible cost and legal expenses savings in addition to time savings. If you have questions about the advantages and disadvantages of arbitration for your particular situation, we recommend that you consult with legal counsel.